It looks as if our numbers are settling down now. So let me welcome everyone to this webinar, looking at pro and anti-member trends in judicial decision-making, which we're exploring through some recent cases, which will be discussed by 4 members of our pensions team. So after that introduction, it's time to get started. Could we have our first poll, please? And that's 67% of those attending so far voted. And of those, it's about 60% pro-member and just under 40% pro-employer, advisor or other. So we'll bear those figures in mind and see what we end up with when the talks have taken place. Thank you. And our first speaker this morning is Oliver Hilton, whose first big involvement in pensions litigation came with HR trustees in Wembley. And since then, he's been involved in a variety of matters, both contentious and non-contentious, and in particular is looking forward to appearing in the Mitchells and Butler rectification claim in July. In his less litigious moments, he has particular expertise in relation to local authority outsourcing. So over to Oliver, thank you.
Thank you, Elizabeth, and good morning. As a matter of housekeeping, I had this room decorated a couple of months ago and didn't have a blind fitted, which I now regret, as you may be able to see, and I'm slowly roasting here. So I shall crack on with my talk without further ado. In the short time available this morning, I'm going to talk briefly about His Honour Judge Hodges' decision in re Britvic, delivered early last year, in which, ostensibly as a matter of construction, he replaced a word in the scheme's rules, the effect of which would be to limit the scope of the employer's power in relation to the rate of pension increases, and thus finding in favour of scheme members whose benefit, it was said, would be less valuable otherwise. To understand Britvic, first, a brief bit of history. Although, for reasons I'll spell out later, and at least some of the audience will appreciate, I can't say too much, and what I do say is based upon a matter of public record. The story begins when George III was on the throne and America had just declared independence, when one William Bass founded what would become the well-known West Midlands brewer, known by his surname Bass. And indeed, when by Queen Victoria's reign, had become the largest brewery in the world. It was just following the Second World War that Bass established in 1946 its pension scheme. And in 1987, increases to pensions in payment and revaluations of deferred pensions were first introduced. Importantly, the increases were by reference to the term official index of retail prices, which was defined to mean RPI or any other index selected by the trustee and subject to a cap. There was thus a trustee power to change the index by reference to which increases were calculated. That changed in 1996 when the trustees adopted a consolidated form of rules using its then new solicitor's standard draft. The draft did not include a definition of RPI, but instead, in one clause, provided that pensions would increase by RPI, subject to the cap, and crucially, by the words in parenthesis, or such other rate decided by the principal employer. In other words, the trustee power was gone, and there was instead a power in the hands of the employer. By 2003, Six Continents, as Bass had then become known, had become a very different business and in a sense had outgrown itself. Its brewery business had gone to Interbrew and Coors, and it was left with one, an international hotel brand, including Holiday Inn and the Crowne Plaza, 2, a domestic pubs and restaurants business, which included all bar one, O'Neill's, Harvester, Toby Carvery, to name but a few, and 3, importantly, a soft drinks business, which included Robinson's, Tango, and J2O, and the franchises to Pepsi and 7-Up. In 2003, there was a demerger. The hotels business went off to Intercontinental PLC. The pubs and restaurants business was transferred, and the soft drinks business was spun out to Britvic. Importantly, a new pension scheme was established for Britvic's employees, which materially replicated the terms of the predecessor pension scheme, and thus inherited the pension increase provisions, as previously explained. It was when Britvic's employer wished to reduce the rate of pension increases in 2019 that battle lines were drawn. The members arguing that as a matter of construction, the words "or any other rate decided by the employer" only entitled the employer to award higher or upwards only pension increases. His Honour Judge Hodge agreed, finding that there must be read in the word higher in place of other, on the basis that taking a more contextual approach compared to the liberal textual approach to construction, and having regard to the price index legislation and, crucially, a benefit summary sent to the proposed transferring members, he concluded that something had gone wrong with the words, and it was clear that the solution was to remove other and replace it with higher. Now, this is an interesting decision because, as the judge himself acknowledged at paragraph 120 of his judgment, the literal meaning of the words "or any other rate decided by the employer" means just that, i.e. the employer can choose a rate either higher or lower than RPI subject to the cap. And so while the judge acknowledged as a matter of law that he should not approach the matter with any preconceptions as to whether to favour the employer or members, it does seem to me, or at least it can be argued, that he went to some length to find for the members here on the facts, on particular facts in Britvic. There are in particular 4 aspects of the decision which are of interest and which are not closed and may very well play themselves out in the next few months of this year. The first is the extent to which the judge was entitled to sidestep the judgment of Lord Hodge in the Supreme Court's decision in Bernardo's and other previous decisions, to the effect that given the distinctive characteristics of pension schemes, the focus, when construing them, is on the textual approach, and thus acting as a constraint on other background material available to the court when construing pension instruments. Lord Hodge had listed 5 such characteristics, but His Honour Judge Hodge, not to be confused with his namesake, had noted that 2 of those 5 characteristics were not present on the facts in Britvic. And he seemed to use that as a reason to throw off the shackles, as it were, so as to be able to utilise the background material and adopt the contextual analysis. It seems to me that there is a question here whether that is really the correct approach, and whether Lord Hodge's list it is really a tick box exercise, and whether it really is possible to pick and choose as the trial judge in Britvic sought to do, ignoring the other important reasons why the court would lean in favour of giving pension schemes their ordinary natural meaning. The second interesting issue is the process of correcting mistakes by construction. Now, if you go back to the 1982 decision of the Court of Appeal in Eastern Pantiles, it tells you that you need to satisfy 2 conditions. First, that there was a clear mistake as to language used in the face of the instrument, and second, it is clear how that mistake should be cured. And if you can't do that, the Court of Appeal said you would need then to fall back on the equitable doctrine of rectification, which, as we know following the recent decision of the Court of Appeal, is difficult to establish and is subject to the court's discretion and, crucially, equitable defences. And this is a topic that Natalie will be touching upon just after me. From that decision, from the Court of Appeal's decision in Eastern Pantiles, what the case is shown is that the court must be satisfied that something has gone wrong with the language. It is a clerical type error of language used rather than its legal effect. That is, you first try and read the text as it stands without adding or subtracting words. And if the words used make sense and are not ambiguous, the authorities say you apply them. By contrast, you are only entitled to apply red ink and rearrange the text to resolve what is a clear error in the language. What you cannot do is rewrite the instrument because it does not accord with business common sense, for instance. Now, the lines between construction and rectification became blurred as a result of Chartbrook, where Lord Hoffman expressed the view that when considering whether there's been a mistake on the face of the instrument, the court was able to have regard to the factual matrix. it was off the back of that His Honour Judge Hodge is famously known for his view that you can achieve, in quotes, rectification by construction, as his 76-page chapter of his book on rectification is entitled. This blurring of the lines, however, and thus avoiding with construction rectification's more demanding criteria, the court's discretion and equitable defences, is in truth a controversial and difficult question, which was remarked upon by Lord Neuberger in the Supreme Court decision of Marley and Rawlings, but left to another case. Could Britvic be such a case? I ask because no one is suggesting that there's anything ambiguous about the wording used. And the way His Honour Judge Hodge gets to the conclusion that something has gone wrong is by reliance on the wording of a summary of the plan's benefits given to prospective members, the transfer of members to the Britvic scheme, from which he was able to conclude what, in the judge's words, were clearly in the minds of the parties. It seems to me, or at least it could be argued, that this is getting perilously close to rectification, and potentially it could be argued crossing the line. That brings me to the third interesting element of the case. If there is a relevant mistake as to language, whose mistake is it that counts? I raise the question because of the rather unique facts of Britvic, namely that the relevant clause was a replication of the words used in the predecessor scheme, which, as I said, had been introduced in 1996. Now, the construction of successive deeds adopting the same wording was considered by Lady Justice Arden, as she then was in the 2011 Stenerline case, where she held that the meaning may change if the context in which the words were readopted is materially different, i.e. there's been a change of circumstances. And His Honour Judge Hodge relied upon that decision in Britvic. The problem, however, is that the circumstances have not really changed in 2003 compared to 1996. And in particular, the summary of benefits given to prospective members utilised the words of similar announcements made to members under the predecessor plan. So even if you could take into account, it's difficult to see how it shows that the draftsman of the replicated Britvic rules fell into error of language in 2003. Now, these issues may well come up for consideration when the Court of Appeal comes to hear the employer's appeal of Britvic in May of this year. However, the fourth interesting point about this decision is that in July of this year, the High Court will hear the trial of the claim by the trustees in Mitchells and Butlers, the pension scheme in relation, Mitchells and Butlers pension scheme in relation to its pension increase provisions. As Elizabeth mentioned, and as some of you in the audience will know, I'm involved in that case, and so I can only say so much about it. But it's worth noting the following points. Now, I mentioned before that the Bass Pubs business was transferred in 2003, and the recipient of that transfer was Mitchells and Butlers, who became the principal employer of the original Bass scheme, which contained the employer power, which was replicated in material identical terms in the Britvic plan. And the trustees' claim in the Mitchells and Butlers proceedings is to rectify the terms of the 1996 deed in respect to the pension increase provision, so as to put back the trustee power and remove the employer power. In the alternative, they maintain that the removal of the trustee power and or the introduction of the employer power were invalid amendments. But interestingly, as an alternative to that, and following Britvic, the trustees have now taken the point that in the alternative, other rate decided by the employer is also, on its true construction, limited in scope to upwards only increases. And also, interestingly, that question is by reference to circumstances in 1996 rather than later. As I say, not to say anything further on that, say that depending on the decision of the Court of Appeal in Britvic and when it's handed down, there's likely to be an interest in interplay with the Mitchells and Butlers trial and the decision in that. So as to the question of the court's trend towards employer and members in this area, it's very much watch this space. Thank you.
Thank you, Oliver. So one so far pro-member case, but we don't know where it may go next. Our next speaker is Natalie Pratt, who became a tenant in Chambers last October when she finished her pupillage. And while she was in pupillage, She saw some of our pensions work and in particular was involved in the Univar rectification case. So over to Natalie.
Thank you, Elizabeth, and good morning, everybody. So yes, the case that I'm looking at today is Univar UK Limited and Smith. And very much like Oliver's case, this is one of rectification. And so this is a decision of Mr. Justice Trower of June of last year, but it was being heard around about this time, shortly before the pandemic really started to dominate our lives. So even without looking at Univar through the lens of pro and anti-member trends, actually it's a very interesting case just in its own right. So it was the first full trial of a rectification case since IBM in 2012. And so it wasn't your usual summary judgment rectification case. In fact, it was quite the opposite. So there were 12 sitting days, 8 of which were given over to cross-examination, including a dozen or so witnesses, one of whom was an expert. It was also the first decision since the Court of Appeal decision in FSHC, certainly in a pensions context, and it might even have been the first reported High Court judgment applying the FSHC decision at all. And you'll remember that FSHC is the case in which Lord Justice Leggett rejects Lord Hoffman's view in Chartbrook that the objective approach to intention is the right one and instead favoured a subjective approach. And the third reason why Univar is interesting in its own right is that it raised defences and also a counterclaim on lots of interesting issues that aren't necessarily dependent on the rectification context. And so these included the issue of whether you can have an extrinsic contract under which members can enjoy benefits that are greater than those that they enjoy under the scheme rules. And it also raised questions of Estoppel. So the 3 issues that fell to be determined at Univar were first, the rectification issue. And so this was worth about £23 million to the company. And the company sought to rectify the 2008 definitive deed and rules. And those rules tied indexation and revaluation expressly to RPI. They also prescribed minimum percentages for the caps on indexation and revaluation. And they also provided for revaluation to be applied annually. The second issue that Univar raised, which I won't spend a huge amount of time on, is whether members who joined from 2 other pension schemes in 2002 were entitled to increases at RPI capped at 5%, as was set out in the relevant announcements. And really, this was just a question of construction of the announcements, and Mr. Justice Trower held that the members weren't entitled to RPI capped at 5%. And the third issue is the one that concerns the effect of representations that were made to members when they were opting out of the DB section and joining the DC section. And it's there where those interesting questions of Estoppel and extrinsic contracts arise. So if we look first at the rectification issue, so the earlier governing documentation of the scheme, which was a 1996 DDR, that tied revaluation and indexation to the statutory requirements. However, the final version of the 2008 deed expressly wrote those statutory requirements into the deed rather than just incorporating them by reference. And the consequence of writing the substance of the statutory requirements into the deed is that if the regime changed and became less favourable to the members, and as we know, it did on the 1st of January 2011, with a switch from RPI to CPI being the relevant index, the members would have been insulated and were insulated from those sorts of changes. So if you compare the 2008 deed with the statutory requirements, the statute would have applied CPI, but actually the deed was applying RPI. The statute would have applied or provided for one-off revaluation, whereas the deed was applying that annually. And also the statute would have applied a 2.5% cap on pension increases from April 2005 and on revaluation from April 2009. And the deed was doing something different. It was giving it was a more favourable regime towards the members. So in one sense, Univar is actually quite a conventional rectification case. So the company's argument is that the 2000 deed was supposed to consolidate all the previous rules into one place. It wasn't supposed to make any substantive changes, but in the event, an unintentional change was in fact made. But in another sense, actually, Univar's quite an unconventional rectification case, because it's not the deed itself that's making any changes to the pre-2008 position. Actually, it's the subsequent statutory changes that are causing the problem and making the change. You also have the added difficulty in Univar that this isn't a case where simply nobody saw the rule and it slipped through the net completely unnoticed. Actually, it was quite the opposite. Everybody had seen the rule, everybody had read it, there had been other amendments made to the rule along the way. Everybody understood that it applied RPI and that the current scheme was applying RPI. It really is just a case that nobody thought that those statutory requirements might change. So unrectified, the 2008 deed was more beneficial to members. And so the pro-member solution here would have been to find a way to refuse the rectification claim. So what was decided? Well, firstly, rectification was ordered. Mr. Justice Trower accepted that neither the company nor the trustees intended the pension increase rules in the 2008 deed to have the effect that they did. And he also held that the 2008 deed was supposed to be a consolidating deed, and the recitals to the deed said that themselves. And actually, the only changes that were intended were those in the drafting schedules, and these particular changes were not in the drafting schedules. Mr. Justice Trower also applied FSHC, as you suspect he might, given that had been the last word on intention. However, he did say that whilst you are looking for subjective intention, that might be objectively manifested, so through the contemporaneous documents, and that might be especially important when you're looking for a collective intention. However, when it did come to collective intention, the judge did manage to sidestep that quite deftly, because he did say that I don't need to really think about whether I'm looking for unanimity or if I'm looking for a majority when it comes to intention, because as a matter of fact, he found that all the trustees did in fact share the same intention. So, is this element of Univar pro or anti-member? Well, I would say that the outcome of the rectification issue is clearly anti-member and pro-employer, insofar as the rectified deed is not as beneficial to members as the unrectified version would have been. But the real question is, did Mr. Justice Trower really have any other choice but to reduce the member benefits in the way that he did? Well, the Rep Ben did give the judge options, and two of those options were to say that actually the 2008 deed was intended to reflect scheme practice, and that did include increases in revaluation reference to RPI. And they also quite heavily pushed the argument that actually it was the statutory change that was the stimulus for the claim, not a mistake in the drafting per se. The judge rejected both of those. He found that actually the 2008 DDR was intended to reflect the benefit structure to which members were entitled, and that was the statutory requirements to which they're entitled. And he also held that the 2008 deed did contain a change of substance by hardwiring the revaluation and indexation to RPI. So notwithstanding being presented with options to make a pro-member decision, the judge did make a very clear pro-employer decision in ordering the rectification of the deed. So this brings me then to the second issue that I want to think about from the Univar case, and that's the opt-out issue. So shortly after the 2008 DDR was signed and was in force, the company then sought to close the DB scheme to further accrual and break the final salary link. And faced with a courage proviso, that had to be done by asking members to opt out of the DB scheme voluntarily and break the final salary link themselves. And in exchange for that opt-out, members were promised, or members were told that they would be eligible to join a market-leading DC scheme. But members were also told that if they didn't opt out, they would not be eligible to join the DC scheme, and the company would take other steps to break the final salary link. And the steps that were floated were a fire and rehire policy, or making any future pay rises contingent on the agreement that they wouldn't count towards pensions calculation. So what arguments did the Rep then put up here? Well, as mentioned, it's the opt-out issue where we get these points of wider interest that aren't necessarily unique to the rectification context. So The opt-out issue was really centred around representations that were made to the members during the opt-out exercise. And so these representations were contained in things like the consultation notice, presentations to members, and also the opt-out form itself. And these representations came in various forms, but it did have the common wording that I've put on the slide here. And generally, members were being told that deferred pensions would increase in deferment broadly in line with inflation, as measured by RPI, up to a maximum of 5% each year for most of your pension. So the wording that comes before the quote on the slide varied slightly depending on which document you're looking at, but the common theme was the wording on the slide here. Now, based on that representation, the Rep Ben essentially argued three things. So they argued that an extrinsic contract had been created. Or second, the argument was that the company was exercising its power to determine the rate of revaluation. And the third argument that was raised was one of Estoppel, and the full suite of Estoppels was relied on, so both in defence and as a counterclaim. So taking those three arguments in turn, so thinking first about the extrinsic contract argument, so the Rep Ben was arguing that they were contractually entitled to RPI capped at 5% in exchange for opting out. And it's well established that you, as a member, can contract to receive less than their entitlement under the scheme rules. And we know that, we're familiar with the South West Trains case. But there's no authority to the opposite. So there's no authority that says a member and a company can contract for the member to receive more than they're entitled to under the scheme rules. Now, in theory, there's no reason why that sort of contract shouldn't be possible. But there might be practical reasons why it's unlikely and improbable. So it would probably be an unusual move for the employer to agree to give additional benefits above and beyond the scheme rules. And that sort of promise and that sort of extrinsic contract might be hard to administer unless the trustees are a party to it, or at least unless they're completely aware of it and on board with it. So in the event, in Univar, Mr. Justice Trower held that actually the only contractual right that was created by these representations and the opt-out exercise was the contractual right to be admitted to the DC scheme. The representation was too vague to bind the company to RPI capped at 5%. And actually, as a matter of fact, it was also found that every member had attended a presentation prior to opting out. And at that presentation, they were told these representations were merely summaries of the scheme rules, and they didn't override the scheme rules in the event of a conflict. The second defence raised by the Rep Ben, so the deemed exercise of a power, this was dealt with very, very shortly in the judgment. And actually, it failed for much the same reason as the extrinsic contract argument failed. So there was no evidence that the company intended to exercise its power to determine the rate of revaluation. And the company also failed to meet the necessary prerequisites under the rules. So they didn't take the advice that they were required to from the scheme actuary, and also they didn't obtain trustee consent. So for those reasons, that argument also failed. That brings me on to the third and final point. So the argument of Estoppel. So as I mentioned, the Rep Ben argued the full suite of Estoppels, both in defence and also as a counterclaim. And it's fair to say that all the parties and the judge took this at a very, very high level of generality. And following the decision in Stereo and Hutchinson, really everyone just focused on the three common requirements of Estoppel that we're all familiar with. So representations, reliance, and detriment. And the Rep Ben failed on all three. However, interestingly, along the way, the judge held that you can't presume reliance. That presumption is confined solely to your classic cases of proprietary estoppel. He said, instead, what you need to do is look at the representation in context and ask whether it's material to the member's decision to opt out. And in this instance, Mr. Justice Trower said it wasn't. And finally, the judge also held here that there was no detriment because it's clear that the company would have broken the final salary link anyway, whether a member opted out or not. And so actually by opting out, they weren't suffering any detriment. They weren't in any worse position. And so finally then, is this element of the decision pro or anti-member? Well, I would suggest that this element of the decision is also very firmly pro-employer and therefore anti-member. And I would say that for three reasons. First, the judge did set a very high bar for representations in opt-out documents to have contractual effect. And second, and relatedly, that's going to give employers a really helpful level of protection if the representations that they make in their opt-out documentation turn out not to be quite right or quite accurate. And so it will give them a lot of confidence going forward in these opt-out exercises. And third, and finally, it seems that actually, as long as you do have an express statement somewhere in this opt-out documentation that says any representation made is subject to the scheme rules and will be overridden by the scheme rules in the event of a conflict, then actually it seems that the employers are very much in the clear when they're doing these opt-out exercises, and they won't be held to their representations. So my overall suggestion is that actually Univar, both on the rectification and the opt-out issue, is very firmly a pro-employer case. Thank you.
Thank you, Natalie. So one from the other side. And our third speaker is Henry Day, who's spent quite a lot of his pensions litigation time involved in the affairs of the British Airways pension scheme, giving him considerable insight not only into the proper or improper exercise of powers, but also the intricacies of applications for better relief and the position of representative beneficiaries. He was also involved in the Barnardo's RPI-CPI case, another favourite theme. And another of his areas of interest is SIPs and SASs, and in particular, the duties and liabilities of advisors and providers. So over to Henry.
Thanks very much, Elizabeth, and good morning, everyone. Following that introduction, I thought it might be interesting to approach the question before us today from a slightly different angle by looking at a couple of recent decisions concerning personal pension schemes and the regulatory regime under the Financial Services and Markets Act and the FCA Handbook. The first case I'd like to have a look at is Adams and Options, formerly Carey Pensions, of which you'll all no doubt be aware. Although the trial took place in early 2018, the High Court didn't hand down judgment until May last year. And of course, the appeal was before the Court of Appeal just last week. The second decision is a determination of the Financial Ombudsman, also concerning Carey, and made very shortly before the High Court judgment in Adams. I think they're quite a useful pair to consider together. As I said, they appeared at almost the same time, and while their facts are remarkably similar, the outcomes in each were very different. So briefly, what happened in Adams? The claim arose out of an investment that had gone wrong. Mr. Adams wanted to release funds from his existing pension and made contact with an outfit called CLP Brokers, who were an unauthorized broking firm based in Spain. On CLP's recommendation and encouraged by a cash incentive that they offered, Mr. Adams proceeded to set up a SIP with Carey, which was an authorized SIP provider and administrator, and transfer into it the entire value of his existing pension, and then to invest these funds in storage unit rentals with a company called Store First. Now, the investment failed to perform as Mr. Adams had expected, and so he brought proceedings against Carey. There were three strands to the claim, but in the interest of time, I just want to mention the two main ones. The third involved allegations of negligence and joint enterprise between Carey and CLP, and was really dealt with very shortly by the judge. So first, Mr. Adams argued that the SIP contract was unenforceable under FSMA Section 27 because, he said, it had been established in consequence of arrangements made and advice given by CLP without authorization, and so contrary to the general prohibition in FSMA Section 19. Second, Mr. Adams said that Carey had breached its duty to comply with the COBS rules in the FCA Handbook by not refusing to accept the underlying investment with Store First, and by providing no advice about the investment or about the decision to transfer. And in this regard, he placed specific reliance on Carey's duty under COBS 2.11 to act honestly, fairly, and professionally in the best interests of its client. Now, unfortunately for Mr. Adams, the court dismissed his claim, and underlying that decision were a number of important findings on facts, of which I think 3 are particularly relevant for our purposes this morning. First, and crucially, the court accepted that Carey carried on the business of establishing and operating SIPs on an execution-only basis. In other words, it acted only on its client's express instructions. Second, the court held that Carey did not and was not authorised to provide advice to Mr. Adams as to whether to establish a SIP or enter into the underlying investment. And then thirdly, and following on really as a consequence of the 2 points I've just mentioned, the court held that the underlying investment with Store First was Mr. Adams's sole responsibility. And unsurprisingly, perhaps in light of all that, the court went on to find that against Mr. Adams on each limb of his claim. So concluded that FSMA section 27 wasn't engaged. CLP's acts as introducer didn't constitute making arrangements within the meaning of Article 25 of the Regulated Activities Order, because they didn't in themselves bring about the SIP. There was no direct and substantial causal connection between the arrangements and the ultimate transaction, because CLP acted as a mere introducer. CLP's acts also didn't constitute advising within the meaning of Article 53 of the RAO. The evidence didn't demonstrate that CLP had provided any advice in respect of the Carey SIP. And it's important to remember that it was the Carey SIP that was the relevant investment for the purposes of the RAO, not the underlying investment in Store First. And so the SIP contract was enforceable. It's also significant, I think, particularly for present purposes, that the court emphasised that even if it had found that FSMA section 27 was engaged, it would have exercised its just and equitable discretion under FSMA section 28 in favour of Carey and allowed the SIP contract to be enforced anyway. And this was largely on the basis that Carey had no knowledge that CLP was acting on this alternative footing in contravention of the general prohibition. The court also found that Carey wasn't in breach of COBS Rule 211. As an execution-only SIP provider, Carey fell within the ambit of the rule, but the court said that the rule's obligations had to be construed in light of Carey's contract with Mr. Adams. And given the parties' respective duties under that contract, and the court's further finding that there wasn't anything unsuitable per se about either the SIP or the underlying investment, the court held that Carey had acted fairly and professionally in accordance with Mr. Adams's best interests. So Carey was under no obligation to refuse to accept the underlying investment or to advise Mr. Adams. And indeed, as I've said, Carey wasn't authorised to provide advice. So all in all, a pretty comprehensively anti-member outcome, at least in the High Court. And so far as SIP providers, and indeed other financial services firms are concerned, an important statement of the nature and scope of their duties. So what about the Ombudsman's determination in the case of Mr. T? The facts echo those in Adams very closely indeed. Mr. T, on the recommendation of the same introducer, CLP, transferred funds from his existing occupational pension schemes into an execution-only SIP, again with Carey, invested those funds in the same underlying investment, Store First, and then when the investment failed to perform as expected, brought a complaint. Significantly, though, rather than the issues raised in Adams, the Ombudsman focused on the question of due diligence and the FCA's principles for businesses, paying particular regard to principles 2, 3, and 6, as well as COBS Rule 211, and also the FCA's published expectations of SIP operators. And in doing so, the Ombudsman upheld Mr. T's complaint, finding that although Carey had made some efforts towards satisfying the FCA's expectations, it had failed to conduct sufficient due diligence on CLP before accepting Mr. T's business. and indeed that if Carey had done so, it should and would have concluded that it wouldn't have been fair and reasonable to accept that business. So a rather different outcome from Adams. This can obviously be accounted for in part by the Ombudsman's emphasis on the question of due diligence. That said, the judge in Adams made clear that if the issue of due diligence had been raised before him, he would have found on the facts in Carey's favour. And there was nothing in Adams to suggest that Carey's conduct in this regard was any different from its conduct in Mr. T's case. Another way of looking at the two decisions is to focus on the different jurisdictions and approaches of the courts and the Ombudsman, applying the broad criterion of what's fair and reasonable under FSMA section 2282. And the Ombudsman accorded considerable weight to the FCA's various published statements on the duties of SIPP operators. In Adams, by contrast, the court looked to the usual legal principles of statutory construction and emphasised that FCA guidance and reviews can't found a legal claim for breach and don't assist in the interpretation of the COD's rules. I think the other thing to bear in mind is that, unlike the Ombudsman, the court reached its decision in Adams after an oral hearing. And during cross-examination, Mr. Adams accepted that he would have proceeded with the investment in store first, regardless of any warnings he might have received, because of his desire to release funds and because of the cash incentive that CLP had offered him. In light of that, the judge found that Mr. Adams's case failed on causation in any event. So those are some possible ways in which the two Carey cases, Adams and Mr. T, and their very different member outcomes might be thought of in relation to each other, if not actually reconciled. I should also say that there have been a number of FOS determinations over the past 6 months where the Ombudsman has referred to Adams. All of them have concerned the conduct of financial advisors rather than pension providers. If there's a theme that emerges from them, it's really the lengths to which the Ombudsman has gone to distinguish Adams. He's taken the view, for example, that Adams is relevant only to the position of SIPP providers, not financial advisors, and that its application is limited to execution-only services. He's also been at some pains to stress that Adams didn't address the application of the FCA's principles for businesses, which of course the Ombudsman can consider, but which aren't actionable in law. So an unhelpful divergence of views between the FOS and the courts does seem to have emerged in this area. The FOS's position could certainly, I think, be characterised as pro-member, while the courts, as in Adams, have been rather more circumspect. There are, of course, other recent cases that could also be brought into the mix. A couple up on the slide there, Barclay Burke and Avocade, but I'm very conscious of time, so I'm just going to end by saying that we'll have to wait and see what the Court of Appeal says and on Adams, and whether that resolves some of the tensions which seem to have emerged here. And with that, I'll hand back to Elizabeth.
Thank you very much, Henry. So we come to our final speaker. Wendy's well-known cases include Gleeds, which tells you all you could possibly want to know about invalidly executed documents, and Capita and Sedgwick Financial Services, which tells you possibly more than you might want to know about limitation and Section 14A. And she's also been involved in a number of cases concerning the Pensions Ombudsman and Pensions Regulator. So over to Wendy for our last case.
Thank you very much, Elizabeth. Now, pensions liberation feels like it's a fairly new thing, but it's actually over 8 years since the regulator's Scorpion campaign. And progress is definitely being made to stop scammers. Cold calling in relation to pensions has been banned since January 2019. However, many people have already been involved in transactions to liberate their pensions, and the courts are still dealing with the fallout from it. Members are finding themselves subject to large tax charges under the unauthorised payments regime. So the two cases I want to look at today, recent cases, when considering how member-friendly the decisions of the court are in this area, are Clerk and Revenue and Customs Commissioners, where I think it's safe to say the court formed a relatively dim view of the conduct of the member, and Board of the Pension Protection Fund and Dalriada Trustees Limited. And that's the case we'll spend a little more time on, because that's got really quite far-reaching consequences for this area. Just to preempt what's going to emerge, I think the theme running through my contribution to the debate is that in liberation cases, the court favours the right sort of member, the member who was unwittingly fooled rather than a savvy trusts buster. So on to Mr. Clark. Mr. Clark, hearing before the Court of Appeal was a second appeal. He had had 2 million in a SIP held with Suffolk Life, but he was disappointed with the returns that investment was generating. He wanted to invest the fund himself, particularly in the London residential property market, an option which was not available to him under his SIP. Now, I don't need to trouble you with the detail of what Lord Justice Henderson referred to in the case as a bizarre series of transactions designed to get the money out and available to Mr. Clark to invest, because as it turned out, the process failed at the first hurdle. The first step in the process was to transfer money from his existing SIP into an alternative occupational pension scheme. But that scheme, which was governed by a trust deed, was found to be void for uncertainty. Now, for anyone thinking a trustee being found void for uncertainty is a rather niche occurrence, I would refer you to the decision of Mrs. Justice Rose, as she then was, in Elizabeth's 2014 case re LPA Umbrella Trust and others, where a similar problem arose on almost identical wording. So the net effect of the receiving scheme being void for uncertainty was this. Whilst the legal title to the £2 million in the Suffolk Life Trust SIP passed to the receiving scheme, the beneficial interest did not. Now, Mr. Clark used the fact that the beneficial interest hadn't passed to argue that he shouldn't be liable for any unauthorised payment charge, as the beneficial interest in his Suffolk Life SIP had never really left the SIP. The problem Mr. Clark faced was that in reality, the money had left the Suffolk Life SIP. It had gone through the chain of transactions and come out the other end and duly been invested at Mr. Clark's direction following the purported execution of all the steps for around 10 years. So it was a very much a technical point that was being run on his behalf. Now, the Court of Appeal dismissed Mr. Clark's appeal. They relied very heavily on the fact that the unauthorised payments regime is intended to have a strong deterrent effect. The court held that the question as to whether a payment is made for the purposes of the unauthorised payment provisions should be answered by looking at the practical business reality of the transaction, including any composite transaction of which the payment forms part. If the intended purpose and effect of the transactions is that money leaves a scheme and is placed at the free disposal of the member, the mere fact that that money might be subject to an equitable obligation to be restored to the transferring scheme doesn't preclude there being an unauthorised payment, because to conclude otherwise would deprive the charge to tax of effect in many of the cases where it was most needed. So no look for the member there. But what about the people who just answered a cold call in good faith or didn't question what they were being told about the loan and the tax consequences or similar? Well, there may be a little bit more hope for them. At paragraph 86 of his judgment, Lord Justice Henderson noted that there may be different considerations applicable in cases where an unauthorised payment is inadvertently or carelessly made, and where the member concerned takes prompt and effective steps to restore it to the fund before any assessments made by HMRC. Now, obviously, Mr. Clark wasn't found to be one of those people, but let's think about whether that's actually helpful. Practically speaking, most members in that situation may end up in limbo. Consider, you've fallen for a scammer and put your money into a receiving scheme. It may be a black hole. How easy is it going to be for the member to get the transfer back to their original scheme? What happens if the transfer was from a scheme that's been wound up, a SIP that was bespoke to the member? So I think, although ostensibly pro-member, it may well be more the appearance of helpfulness here as opposed to practical help from the court. So turning to the second case, and this is where the court's made the largely pro-member decision. I think it's probably important to give a bit of context about this case. The board of the PPF administer the Fraud Compensation Fund, and that's funded through a separate levy on all occupational schemes, DB and DC, and it can pay compensation to members of eligible work-based pension schemes where the employer is insolvent and where the schemes have lost out financially as a result of dishonesty. Now, to date, there haven't really been so many calls on the fund. In its September 2020 annual report, the PPF acknowledged this, that claims have been historically low, but noted that in the event that schemes which were themselves part of the scam were eligible to claim on the fund, there could be large claims in the pipeline. And indeed, in the case, Dalriada suggested about £350 million worth of claims, which, considering the levy for the 2020 year was 6.9 million to the Fraud Compensation Fund, we're dealing with significant sums. That report also was careful to note that any funding gap would need to be considered by the DWP. And the DWP actually were an interested party in the case that we're going to talk about. Judgment was handed down in November 2020, and the case was effectively a test case. Dalriada chose a scheme as the vehicle for the claim, and that was the Turnberry Wealth Management Pension Trust, and I'll tell you a little bit about that in a moment. But it was acknowledged that Dalriada was the trustee of a number of similar schemes, which all shared similar characteristics and were eligible claimants for the fund, potentially. Now, the Turnberry scheme had lost 2.684 million, which was about 80% of the sums in the fund, by investing in shares in Elysian Fuels, which it had purchased from a BVI company. So far, so exotic. The business of fuels was actually rather more down to earth than its name suggests. It was actually for the construction of a bioethanol plant in Grimsby. The shares were totally worthless, and some of the money paid for those shares ultimately found its way back to members by way of loans from a connected company. So it was a fairly standard loan-based liberation structure, all in all. Liquidation of the employer and a scheme failure notice duly followed. Now, the Fraud Compensation Fund was established under Part 2 of the 2004 Act, and it will make payments in certain circumstances, which is set out in Section 182 of that Act. The 6 conditions are very well summarised by the judge at paragraphs 27 to 33 of the judgment, but I don't need to go into them now. The crucial element for present purposes, considering how pro-member these decisions are, is that there must be an employer and there must be some form of scheme failure notice in order to engage the jurisdiction of the Fraud Compensation Fund. Now, overall, the questions were generally decided in a pro-member way because they were all designed, as I see it, to facilitate rather than block a claim from a scheme involved in pensions liberation. So I've set the questions out on the slide, but the first question concerned the relationship a company needed to have with eligible members to qualify as an employer under the Act. Now, Mr. Justice Trower found that a person could be an employer of a scheme with eligible employees who were retained under a contract of service, where those eligible members were remunerated office holders, or even if they were only unremunerated office holders. Now, the reasoning was quite lengthy. Mr. Justice Trower acknowledged the circular definitions in the pensions legislation, cross-references in some parts of the 2004 Act to the Pension Schemes Act, lack of cross-references in other. But ultimately, it was a fairly pragmatic approach he took because his construction, which permitted unremunerated office holders to still have an employer for the purposes of the Act, meant that all the schemes that contribute to the levy can potentially benefit from the fund, which means the widest possible access to the fund because of the wide definition of employer. So that's a pro-member answer. The second question related to what constituted the employer's pension liabilities under the scheme. Now, that's an important question because that's a requisite element of a scheme failure notice. And without a scheme failure notice, the board has no duty to pay out of the Fraud Compensation Fund. Again, the court gave a very pro-member answer. The employer's pension liabilities under the scheme are not limited to legally enforceable rules under the scheme relating to the employer's obligation to contribute. It would also cover obligations which indirectly facilitated the trustee's ability to fund benefits, for example, where the employer pays expenses which would otherwise fall on the scheme. It covered sums payable under statute, such as Section 75 debts, and sums payable to the trustees of the scheme by way of claims in tort and equity, for example, under trust law, where there'd been some dishonesty. It also expressly covered sums required to be paid by TPR under various provisions of the 1995 Act. It was further held that even if there were no employer liabilities under the scheme, a scheme failure notice could still issue so long as no one else had taken on liability for the employer's obligations. So again, it's a pro-member decision as it lets the widest range of schemes into the scheme failure notice regime, which in turn lets them benefit from the Fraud Compensation Fund. The third question, which Mr. Justice Trower answered in a very pro-member way, concerns what sums lost to the scheme can be treated as being attributable to the dishonest act. Now, the costs and expenses incurred by an independent trustee who takes over a scheme that's been run as a pensions liberation vehicle can be very significant. Even if the scheme trustee ultimately manages to recover all of the misappropriated funds, and recoveries are brought into bear in a claim against the full compensation fund, the scheme trustee will still have incurred huge costs, and those are in principle recoverable in the various categories that I've set out in the slide. And I think the most significant point here for members is that an innocent member whose funds have gone over to the scheme but haven't received an unauthorised payment might have found their funds depleted by scheme sanction charges in respect of other members. So the fact that the scheme sanction charge is potentially recoverable, that's the tax liabilities on the scheme for the unauthorised payment on the slide, is very helpful for those members. And then we have the final answer or non-answer, and I'll explain why I've characterised it as that shortly. And I like to think of this as the revenge of the Clark case. This was a very specific question as to what happens in cases of sham. Now, first of all, a caveat. Dalriada in their submissions submitted that it is incredibly unlikely for a sham to have been the case in relation to any pensions liberation scheme, because the intention of the person setting up a pensions liberation scheme will have been to act under the terms of the trust deed and rules in a way which permits them to effect pensions liberation. And Dalriada said that once there's an intention to use the powers under the occupational pension scheme or to hold some of the assets pursuant to its terms, then the scheme in question simply can't be a sham. And it also pointed to the fact that in a case of the type contemplated in this hearing, there would have been a clear intention to create a genuine trust. Now, it's true that no case involving a sham has been found since the prospect was floated in Pye Consulting. And given the finding of the court in relation to the issue of sham and the effect that a trust, a receiving scheme being a sham would have on Section 95 of the Pension Schemes Act, no member is going to run the point, because the judge found that if the scheme was a sham, the transfer from the originating scheme in would be a breach of trust, a breach of duty, not compliant with Section 95. So that would cause the same issue to arise as arose in Clark, that the legal interest would transfer, but the beneficial interest wouldn't. But it would still potentially be capable of constituting an unauthorised payment. So it won't help the poor member because they're stuck potentially with an unauthorised payment because it wasn't a recognised transfer. There were some ancillary points, but fundamentally, Mr. Justice Trower found that he couldn't make definitive declaratory rulings on the point because there were too many variables. He did note that TPR purporting to appoint an independent trustee in a case of a sham trust wouldn't work because TPR's jurisdiction is engaged only in respect of valid occupational schemes, although he did consider that the parties weren't arguing that a court of appointment of the trustee would not be effective because the court's got a much wider jurisdiction. So overall, Dalriada, Board of Pension Protection Fund and Dalriada is a tremendously helpful decision for members because it potentially lets schemes which have suffered great loss through liberation claim the benefit of the full compensation fund, even if they were originally a vehicle for liberation. So I think overall, it's a pro-member decision. Thank you.
Thank you very much, Wendy. Time is very short, but I think in fairness to those who submitted questions in advance, we will at least try to answer them. So the first question is, please can the panel comment on the pro-stroke anti-member trends, specifically in relation to member complaints concerning pensions liberation stroke transfers? And I'd also be interested to hear if the panel thinks there's a difference in approach between the Ombudsman and the courts as far as pro and anti-member trends go. Wendy, I think to some extent you have answered that question, but is there anything to be added to what you've said in your recent talk?
Well, obviously, I focused on court-based decisions. I think the approach of the Ombudsman has varied. There was a rash of these Ombudsman cases back in sort of 2014-15, but then there was something of a pause. Recent cases have included the Ombudsman always comes down very hard on the receiving scheme. Quite often you'll get maladministration payments for failure to transfer out to a legitimate scheme. The Ombudsman will also come down hard on a transferring scheme that transferred after February 13, which was when the Scorpion guidance came out, without undertaking due diligence. Obviously, the Ombudsman, the Pensions Ombudsman, can sometimes be more member friendly because it can make payments for maladministration, but it's generally subject to the it applies the law quite diligently, I think. So I don't think there's too much of a discrepancy between their approaches. I don't know whether Henry has any views on how FOS treats things.
Yeah, I mean, I just echo what Wendy said. I mean, I think what is of interest is, going back to some elements of my talk, the difference in the criteria that FOS on the one hand and the Pensions Ombudsman on the other apply. I mean, I think in broad terms, you're going to see the Pensions Ombudsman broadly aligned with the courts, bearing in mind the nature of its jurisdiction and the way that it has to handle cases. And as I've tried to suggest, I think the FOS is rather more of a sort of a member-friendly free-for-all. There is a case I have on at the moment that involves a previous Pensions Ombudsman decision. The facts and the legal arguments were quite similar to those in Adams. The Ombudsman gave his determination there back in 2016. And I think it's quite interesting that he came down in a very similar way to the High Court in Adams, emphasising the importance of the contract between the SIP provider and the member, and effectively saying that the member was responsible for his own investment decisions. So I mean, that's just one example, but I think in broad terms that would be my view.
Thanks, Wendy and Henry. And the second question that we had, again, involves the Ombudsman, in fact. The question is, given the recent Ombudsman case of Mr. N, the InnerSpec scheme, where the Ombudsman accepted the limitation arguments, do you think the Ombudsman is more likely to consider limitation arguments than expected historically? I think you're in the firing line still, Henry.
Yeah, it's an interesting question. I mean, I think the key point about Mr. N and InnerSpec is that the two of the 3 points at issue were so egregiously out of time at law. I think the defaults in question were something like 20 years prior to the actual complaint, that really the Ombudsman's hands were tied. So whilst, yes, he might be willing to waive the usual 3-year period in which to bring complaints, that doesn't trump the Limitation Act or wider considerations there. So I don't know whether that particular complaint, Mr. N and InnerSpec, is likely to signal any particular sort of new departure, and it seems to me to reflect the established nature of the Ombudsman's jurisdiction and the requirement that the Ombudsman follow the law effectively. So where a claim is out of would-be statute barred, then the Ombudsman needs to approach that accordingly.
Thank you. So I think we'll just run our poll again and then conclude the seminar. Could we have the poll for the second time, please, to see if anyone's views have changed over the course of the past hour? Thank you. That's just over 57%, I think, voted. And yes, we've got quite a shift actually, down to 48% pro-member and 52% pro-employer. Of course, what a properly organised poll would have done would have been to include the option neither. There's no trend either way, and possibly, particularly given the example of Mr. Justice Trower, who was extremely pro-employer in one of our cases and pro-member in another, perhaps that's ultimately the true answer. But it's sometimes an interesting way of looking at it, and certainly provides food for thought, including the food that will be generated by a number of those decisions being subject to appeal later in this year. So it remains for me to thank you all again for attending this webinar and hanging on to the final stages of it. I hope it's provided an interesting lens through which to look at some significant recent cases. So thank you and goodbye.